retailers' continued expansion of private label assortments can, at times, feature packaging designs that are similar to their national brand counterparts, and this could lead to legal action. In 2025, we saw two major national brand conglomerates file lawsuits against prominent retailers. Mondelez International sued Aldi, with the former claiming the grocer blatantly copies its snacks and sells the product in packaging that is likely to, quote, deceive and confuse customers. Additionally, J.M. Smucker sued Trader Joe's, claiming the grocer's frozen peanut butter and jelly sandwiches violate trademarks of Smucker's Uncrustables. Welcome to Store Brand Spotlight. I'm Greg Sleater, Executive Editor of Store Brands. Our guest is Elizabeth J. Rest, an intellectual property attorney and co-founder of San Francisco-based Crown LLP. Elizabeth will discuss legal protections for food packaging and product presentation under trade dress law, when private label packaging may cross the line into infringement on another brand's look and feel, and share best practices for grocery retailers and CPG brands alike to safeguard their brand equity and minimize legal exposure. Elizabeth, welcome to the podcast.
Thank you for having me.
I'm excited to have you because we all think we know the law, and unless we're trained in the law, we don't know the law. So it's great to have somebody who is well-versed in this to talk about a topic that we're seeing creep in a little more and more as the major national brands kind of push back on the growth of private label. And it's interesting to see some of that legal action and how it plays out. So this is a good topic for us. We don't get into legal issues all that often, but this is a fascinating topic. So I'm looking forward to this discussion.
Great, me too.
Elizabeth, to start with, can you define trade dress for our listeners, particularly as it applies to food packaging and product presentation, and talk about exactly what that law protects?
So trade dress is a subset of trademark law. So broadly speaking, it protects the look and feel of a product. And that can fall into two general categories. The first category is product packaging. So the graphics, the design, the layout, the words, the packaging itself. The second is product configuration. So the shape of an actual product. Some examples are the iconic Coca-Cola bottle, the shape of that bottle, the Hershey's Kiss, the goldfish cracker. Those are all product configuration protected trade dress. And in the food industry, it can also apply to restaurant design. So for example, the red and yellow interior of a McDonald's or the ornate Asian design of a P.F. Chang's restaurant. So it's all of those things combined, the look, the feel, the design aesthetics of a product.
It's interesting you talk about shape of things, and you mentioned the Coca-Cola bottle. Is the shape or shapes, are they trademarked to protect those, protect the integrity of those products?
Yeah, so that's exactly right. So the shape of a product can be protected trade dress. It's a very high bar, and we can talk about what that is. But the product configuration, the shape of a product, the bottle, the cracker, the Hershey's Kiss, the Toblerone bars that come in little triangles, those are all protected trade dress, which when you register with the USPTO, it shows up as a trademark. It doesn't say trade dress, but because it's a product configuration, it's a trade dress protection.
Understood. That's interesting. So last year we saw, and I mentioned it earlier in the opening, Mondelez and J.M. Smucker file suits against Aldi and Trader Joe's, respectively. For when you're trying to prove or establish that trade dress they're infringing on trade dress, what elements does a brand have to prove?
So the first thing they have to prove is that they have protectable trade dress. That's the same in any kind of copyright, trademark, et cetera, litigation. First, you have to prove that you have rights as the plaintiff. And proving that you have trade dress and that it's protectable trade dress is, like I said earlier, a pretty high bar. And then you have to prove that the other side has caused confusion in the marketplace. And it's what you mentioned earlier, the deception. Are consumers going to be confused when they see these two items on a shelf? And there's a lot of factors that go into that and whether or not there is a likelihood of confusion.
Are there limits to what trade dress law can protect when we think about, the food and how it's sold in the packaging that it's sold in?
Yeah, absolutely. So trade dress has to be a trademark. So it has to uniquely identify the source of a party's goods and distinguish it from others. I'm talking about US trade dress right now. The law differs in other countries. It must be used in US commerce. And one of the most important aspects of trade dress protection and enforcement as well, because you have to have an protectable trade dress in order to enforce it, is that it doesn't extend to any of the functional elements. So using my prior example of the Coca-Cola bottle, you could have a bottle of any shape and it wouldn't make the liquid taste better. It wouldn't, do anything other than provide a reputation for the product itself among consumers. And the main test and the same is true for the two examples I gave earlier too, with the Hershey's Kiss or the Goldfish cracker. Those shapes don't do anything functionally to the design of the product. So the main test that they ask is whether or not the shape, the configuration would, if you provided exclusive rights to one party, would it put the competitors at a non-reputation related disadvantage? So using a non-food example, just because it's a fairly obvious one, would be neon colors for safety equipment. If only one party had exclusive trade dress rights to use bright colors, neon colors with safety equipment, that would put their competitors at a huge disadvantage, not just a reputational disadvantage, but a safety disadvantage. So that's going to be considered a functional element. The last aspect that they look at is distinctiveness. And this is whether or not the design itself is distinctive and that it's different from other designs. And there's two types of distinctiveness. There's inherent distinctiveness, which is in and of itself. The minute it's created, it's distinctive. And product packaging can rise to the level of inherent distinctiveness. So that's the overall combination, the arrangement of colors, words, graphics, layout, etc. But product design, the shapes that I've been talking about, for example, they can never be inherently distinctive under the law. They always require what's called secondary meaning to acquire distinctiveness. And this is usually done by mass marketing campaigns. You'll see things like look for the shape of a fish cracker, things of that nature. One of my favorite examples is the Toblerone bars that I mentioned earlier that come in a triangle. They have a honey flavored candy, and they had an entire marketing campaign that they were using triangular honey from triangular bees. And the purpose of that is to reinforce that shape design in the minds of consumers and to make it distinctive. So those are the tests to determine whether or not a trade dress is enforceable.
That's interesting. So like a milk carton or a wine bottle, that's very commonly used. Nobody can limit you from using that.
That's exactly right. So something like a milk carton, first of all, it would be generic. Second of all, it very likely serves a functional purpose. And to take that away from competitors would be unfair. Another example is things like colors. For example, the color green is commonly used with organic foods. It would be very unfair to limit that to just one party. But that said, colors can be protected trade dress. For example, the color purple is protected by Cadbury. And you'll see when you see Cadbury candy, it's always in a purple package. Another one is orange, brown, and tan, which is protected trade dress for Reese's peanut butter cups.
That's interesting. The legal aspect of this I find fascinating because it's
Me too.
all the subtle little differences. It's really interesting to kind of dive into this. The other issue too, and I think this has come up in the two lawsuits that I mentioned, and we could see more of this happen, is that some private label products have a similar look to national brands and use similar schemes and fonts and layouts on packaging. Um, where is the line, I guess, between inspiration, for a retailer to kind of want to look like it, but not completely, replicate it, and imitation, and where does that cross into trade dress infringement?
I wish I could give you a bright line rule that your listeners could follow and say, if I never pass this line, that I'm never going to be infringing. But that's just not the way it works. Trade dress litigation, trade dress comparison is very fact intensive. And so it really depends on the circumstances. Courts, if there is litigation, are going to look to a number of factors. First, they're going to look at, as I mentioned earlier, whether or not that prior user, the national brand, for example, has protectable trade dress. Just because they use yellow yellow on their packaging doesn't mean that that's protectable trade dress. There may be other reasons that they use yellow, or it may not rise to the level of the protection of all those things that I mentioned earlier. So they'll look at that. Then they're going to look at multiple factors to determine whether or not consumers are likely to be confused. And with that, they're going to look at the overall commercial impression of the party's respective trade dress. And if you are a private label brand and you are copying, that commercial impression is going to be fairly similar. They're also going to look at whether or not the private label brand has a house mark on it. So for example, Safeway Select or 365 by Whole Foods Market. And I'm a little hesitant to say that because it's not a bright line. Don't want your listeners to think that if you put your house brand on it, then there's no infringement, but it certainly helps. Another thing they're going to look at is how purposeful is the copying. So courts are very concerned with intent. So when you look at these, is it really obvious that, that you copied, and where on the shelves are they going to be? Are these going to be right next to each other? If so, then you're going to have a higher burden as a private labeler to say, no, consumers are not going to be confused here.
So when we talk about consumer confusion, we're making assumptions based on a legal standard, then we're not actually asking the consumer, hey, are you confused?
That's right. So, every state, just to confuse things, has a different standard for what is a likelihood of confusion. There is a federal standard, but it depends on where you are. They're all very similar, and they're multi-factor tests. I won't bother going through all the factors. Some of them include more than 20 factors, so I won't go through all of them. The most important factors for trade dress are one that I mentioned was intent, was purposeful copying. The other is going to be whether or not these items are going to be close to each other on a shelf. And then the other one is going to be whether or not there's a house brand on it. But one thing that's very good news for private labelers is that courts seem to be pretty hostile to big brands suing private labelers. And there's a number of reasons for that. One is that they're going to assume that consumers know what they're shopping for and where they're shopping, and they're not going to be confused. As consumers, we know that there are private label brands out there. Another thing is that there's going to be a cost difference between the national brand and the private label brand. So I'm not going to accidentally buy the Oreos that are on the shelf next to the Cheerios and think I'm getting the deal of the century if it's half the cost. So the question is whether or not an ordinary American consumer would be confused. So we're not talking about people that work in the food industry, people that work in retailing. It's the ordinary American consumer seeing two products on a shelf. How much are they confused, and how likely are they going to buy the private label brand accidentally when they meant to buy the national brand?
That's interesting when you talk about shelf positioning, because if it's a type of a chocolate chip cookie, they're going to be next to each other because they're in the cookie aisle.
Yeah. And that's the point of a private label brand, right?
Right. You're not going to put the other cookies around the corner. That wouldn't make them, from a merchandising standpoint, that makes no sense.
Exactly.
But you kind of conjure up to me an interesting question when we talk about Trader Joe's, because Trader Joe's sells no national brands. They sell only their products, and every product in the store's got the Trader Joe's name on it. So for like a J.M. Smucker to say, well, they're infringing, there's no confusion, at least in my mind, because the Smucker product is not on the shelf.
No, and that's right. And, like I said, these are multi-factor tests. So shelf space and shelf placement is only one of the factors that courts are going to look at. Smucker's, they have very strong trade dress. They, the idea of trade dress is that you can look at something. You can look at a Coca-Cola bottle, for example, and you know what it is. You don't need to see any of the word Coca-Cola on it to know that it's a Coca-Cola product. And that's true of a lot of trade dress, very strong trade dress. The point of it is that it's distinctive in and of itself, that you don't need to see the brand name. But, companies like Trader Joe's, when they are going up to that line, using the same color schemes, for example, that is pushing the envelope a little bit, even though they're not going to be close to each other on a shelf. There could be the idea that Smuckers, for example, sponsored, endorsed, or were some way affiliated with Trader Joe's and said, here, Trader Joe's, sell this product. And put our trade dress on it, but slap your house mark on it. And again, these are multi-factor tests, so the house mark's not going to do it. Shelf space isn't going to do it. It's a totality of the circumstances test.
Can you dive into the term commercial impression in terms of what that means and then how that's used? Well, how do you assess the overall commercial impression of private label packaging versus a national brand?
Sure. So commercial impression is the same for national brand as it is for private label brand. It's the overall look, sound, meaning of a particular product. So when you're talking about a word, of course, you're talking about what does it sound like? What does it look like? When you're talking about design, it's where are the colors? How are they on the package? Is one on the left side, one on the right side, et cetera. And it's not defined by any single element. It's that entire look and feel that a consumer gets when they look at a product. And then what are they going to remember about that overall appearance? So, for example, if you see a Cheerios box and it's bright yellow, maybe you associate that with Cheerios. So that's the overall impression of the look and feel of the packaging.
Interesting. Private label is continuing to grow, and the grocers and the retailers, I shouldn't just say grocers, but retailers more broadly are driving this growth. Um, as, as they launch new products, can you share some thoughts or best practices for the retailers to ensure they kind of minimize their legal exposure, but while they're still trying to achieve some type of aesthetic?
Course. I mean, look, as a trademark attorney, I'm always going to tell people to try to create something distinctive and on its own. But I understand with private labeling that the goal often is to mimic or imitate a national brand. So the first thing I would always say is that packaging and trade dress guidelines should be part of any private label agreement. And make sure that not just your legal team, but that your designers know what those parameters are and that they are adhered to very, very strictly. Also, if you are going to be emulating a protected trade dress, something that's actually registered with the United States Patent and Trademark Office, look it up. Some of the descriptions are very, very descriptive. So they'll say things like 80% of the package is yellow. The logo on the right appears in this size font. It uses particular Pantone colors, etc. So, for example, if you're copying that, and you say, well, 80% of this package is yellow and the logo is on the right-hand side, maybe you only make 60% of your package yellow and you put the logo on the other side. That's not going to be the end all. It's still going to be a fact by, case by case analysis. But at the same time, those are things that are going to help. And I mentioned Pantone colors. If a registration says we use Pantone color X, don't use that. If it's a particular type of green, use a different type of green. Try not to use things like compared to, which I see all the time on private labels. So for example, if I want to buy Tylenol, right next to it on the shelf at Target is the Target brand, and it'll say compared to Tylenol. It's not don't ever do this. You see it all the time, but it's something that is going to make it harder to show that you weren't copying, because obviously you're admitting that you are copying. Try to add your house brand. Like I mentioned, the Safeway Select or the 365 by Whole Foods Market. Those are not end all either, but those kinds of things help. And try to be unique and distinctive, even if you are trying to imitate or try to copy. Studies have shown that packaging innovation has a direct impact on consumer behavior. So why not try to make your package look different enough that I look at it and I want to buy that rather than the national brand?
The compare to thing is interesting because that has been so commonly used for so many
Yes.
years.
Yes.
That's not something like somebody just invented. And I think the drug chains, more than anybody, use those on pain relief and different kind of
Absolutely. Yeah.
over the counter medicinal products. So it's funny that you offer that advice. Yet that has been a very common practice for many, many
Well,
years.
exactly. No, it absolutely is. And I'm never going to tell a client, don't do it, because, a lot of clients want to do it and they want to put their package and they want you to be able to say, my ODO's product, compare it to Cheerios or, whatever it may be. So, like I said, it's the overall commercial impression. I'm going to keep coming back to that because that really is what courts are going to look at. And if the compare to wording is there, it's just one factor they're going to consider in the multi-factor evaluation of whether or not this is just an imitation or whether or not it's an infringement.
And when you talk about designers looking at the trademark applications of other brands, those applications have to be real specific. The government, from what I understand, is very intense on offering as much specifics on a product as possible. So there's a lot of information you can glean off those, right?
Generally, it depends how old they are. So the USPTO has gotten stricter as years have gone by. If you're looking at something from 50 years ago and some of these the iconic Coca-Cola bottle, that's not a new trademark registration, for example. However, it will have the exact design of what the bottle looks like on it. When it comes to newer things, they are fairly exact. So they will use things like Pantone colors. The USPTO does not require the use of Pantone colors. You can say green or yellow, but they do like it. And as a trade dress owner, it behooves you to use things like that because then you are very specifically saying, this is what we own, this is what we claim, and this is what we're going to enforce. And keep in mind that an infringement doesn't have to be an exact copy. The test is likelihood of confusion. So let's just say that I use Pantone color X and the private label brand uses Pantone color Y. That doesn't mean that there's not going to be a finding of a likelihood of confusion. It simply means that it's one factor in the analysis.
And as private label becomes more of a thorn in the side of these major national brands, do you think we'll see more of this type of litigation going forward as the national brands look to push back?
Absolutely, yes. So there's a lot of reasons for that. The more copycats there are in the marketplace, the more litigation there is in the marketplace. I hear from my food industry clients all the time, everybody copies everybody. But that doesn't mean that it's okay to do it. So, that's like your mom telling you if everyone jumped off a bridge, would you do it too, right? So, you still have to abide by the law and by the parameters. One reason that this is going to become bigger and bigger is that the food industry is the world's largest industry and is highly, highly competitive. And huge amounts of money, substantial resources go into promoting distinctive brands. So the more money spent, the more protective those brands are going to be. Another aspect of this is social media. It used to be that maybe you saw a product in the store and maybe you saw a television commercial or you saw it in a magazine or something like that, but you weren't inundated. We are inundated by social media at this day and age, and you can't go on social media without seeing ads for products constantly. So the more widespread that becomes, the more protective the trade dress owners are going to be. The other aspect of it is, just like lots of areas of law, trade dress law is evolving. The more litigation there is, the more the laws are going to evolve. And we've seen that even over the past couple years where new tests have been created for a likelihood of confusion and new standards have been created.